Have you ever heard someone say, "I just want full custody of my kids," and then watch them go through a divorce, only to end up with something completely different? It happens more often than you think. Welcome back to Due Process Daily, where we break down the law, the system, and your rights, so you're never left in the dark during one of the most stressful moments of your life. Today, we're diving into one of the biggest misconceptions in family law. Why getting full custody during a divorce is so incredibly difficult, even when one parent feels they have every reason to ask for it. Let's start with the basics. In most divorces, full custody is a phrase thrown around a lot, but it's often misunderstood. There are actually two types of custody: legal custody and physical custody. Legal custody refers to who gets to make important decisions about the child's upbringing, things like education, healthcare, and religion. Physical custody, on the other hand, refers to where the child lives and who they spend most of their time with. Now, when someone says they want full custody, they're usually asking for both sole legal custody and primary or sole physical custody. That means they want to be the decision maker and have the child live with them almost exclusively. Sounds simple, right? But here's the kicker. The court doesn't care about what either parent wants. The court only cares about one thing: the best interest of the child. And that's where things start to unravel for people who assume that full custody is easy to get just because they believe they're the better parent. Let's unpack why so many people struggle with getting full custody during a divorce. First, courts in the United States and in many other countries start with a basic presumption that it's in the child's best interest to have a relationship with both parents. That means joint custody, whether legal, physical, or both, is often the default starting point unless there's a compelling reason to do otherwise. So if you're walking into court asking for full custody, the judge is essentially asking, why should I cut the other parent out of major decisions or limit their time with the child? And that's a high bar to clear. You see, courts don't want to punish one parent just because the marriage ended badly. They don't grant full custody based on who cheated, who moved out, or even who filed for divorce. Those are emotional issues between spouses, but they're not enough on their own to convince a judge that one parent is unfit or that full custody is necessary. To truly win full custody, you have to demonstrate one of several things. First, you may have to prove that the other parent is unfit, legally unfit. That could mean they have a history of abuse, neglect, substance abuse, mental health instability, or dangerous behavior that puts the child at risk. Second, you may need to show that the other parent is consistently unavailable, unreliable, or disinterested in being involved in the child's life. Maybe they fail to show up to visits, don't participate in schooling or medical decisions, or simply disappear for long periods of time. Third, in some cases, geographic distance can be a factor. If one parent moves far away, joint physical custody may not be practical. But even then, that doesn't always result in full legal custody being awarded to one parent. And here's something most people don't expect. Even in situations involving bad behavior, courts will often still try to keep both parents involved, maybe through supervised visitation or limited parenting time, rather than cutting them off entirely. So when people walk into court emotionally charged saying, "I want full custody because my ex is terrible," they often run into a legal system that doesn't operate on feelings. It operates on evidence, documentation, and statutes that prioritize shared parenting. Another common reason people struggle with getting full custody: they don't have the right strategy. Too many people think showing up to court and telling their side of the story is enough. It's not. Courts want to see patterns, not just isolated incidents. They want to see school records, medical notes, police reports, therapist evaluations, documentation of missed visitations, or failed drug tests. The more thorough and credible your evidence, the stronger your case becomes. But if you come in with vague accusations and no real backup, you're probably walking out with joint custody, whether you like it or not. There's also a tactical issue. Some parents unintentionally sabotage their own custody case. Here's how. They badmouth the other parent in front of the kids. They withhold visitation without a court order. They ignore temporary custody arrangements or don't follow court rules. Even if their concerns are valid, judges may view these actions as signs that they're unwilling to co-parent or respect the process. And that can backfire hard. Judges want to see that a parent is willing to foster a positive relationship between the child and the other parent. If you're seen as gatekeeping or trying to alienate the child from the other parent, it could hurt your chances of getting the very custody arrangement you're fighting for. And here's another layer: the role of attorneys and court-appointed professionals. In many high-conflict custody battles, the court may appoint a guardian ad litem or custody evaluator to investigate the home life, parenting, behavior, and overall environment. These professionals often speak directly with the child, observe parental interactions, and make recommendations to the judge. If those recommendations favor joint custody, you'll need a very compelling counter-argument to get full custody instead. Also, age matters. As kids get older, many courts consider their preferences. A 14-year-old who says, "I want to live with both my parents," is going to carry more weight than a 4-year-old who doesn't know how to express themselves yet. While children don't get the final say, their voices can influence the outcome. Now let's talk about gender dynamics, because yes, they still matter. Historically, mothers were far more likely to get primary custody. That's changing. Many courts today strive for gender-neutral decisions. That means fathers are just as likely to win joint or even full custody, especially if they've been active, involved, and stable figures in the child's life. But many parents, especially fathers, walk into court thinking the deck is stacked against them. Others walk in overconfident, assuming full custody is a lock because of their role during the marriage. Both assumptions can lead to major disappointment. And finally, there's the practical reality. Full custody isn't just a legal title, it's a lifestyle commitment. So when you zoom out, the reason people struggle with getting full custody becomes clear. The legal system is designed to support children, not to reward or punish parents. To succeed in a custody case, especially when seeking full custody, you need more than just a belief that you're right. You need evidence, you need preparation, and you need a strategy that reflects the real-world standards courts apply, not just the emotional logic people bring into the courtroom. So if you or someone you know is going through a custody battle, take a step back and ask, what's best for the child? What will the court want to see? And what can I do today to demonstrate that I'm ready, willing, and capable of putting my child first? Thanks for tuning in to Due Process Daily. If you found this video helpful, informative, or eye-opening, help us keep the channel growing by liking the video and subscribing to the channel. The information contained in this video is for informational purposes only and does not constitute legal advice.